Hello friends, myself Pradeep Yadav from cdjcollege College of Commerce. Welcome to all. We have started our Law means Business Regulatory Framework subject. In that we have started our first chapter, Law of Contract General Principle. Basically this is a chapter which is consolidated or conducted for the Indian Contract Act 1872. In that, in the last few of the videos we seen what is mean by contract, what is the basic elements of the contract, what is the valid contract, types of the contract. In last video we seen what is mean by offer. So for today's lecture, today's video, we will going to see what is acceptance. What is acceptance under section 2B. So what is acceptance? Under section 2B of Indian Contract Act, section 2B, the person to whom offer is made, he signifies his assent to do that thing, then offer is become accepted. Then offer is accepted. When the offer is getting acceptance, it's become proposal, and a proposal has various legal rights. So from this definition we can understand that what is the basic importance of this acceptance, because whenever you are giving a valid offer, then just only your offer is not become contract. Whenever the next step of the contract is whenever happened when your offer is going to be accepted, and so the acceptance is very important role played with when you are making a contract with any person. So it is important to understand what are the basic elements or what are the valid elements of your any contract. So acceptance. So we seen that the acceptance means when the whom person we are making a proposal is going to be accepted that proposal. So what is the acceptance? Whenever we agrees to do anything from whatever the proposal is making to you, so that is called as a acceptance. And acceptance means we are ready to do that thing for something of the consideration. Whatever the consideration is considered into that your offer, we are ready to do that, so we are showing our acceptance. So all of these terms are concluded between your acceptance. So now we are see what is the valid elements relating to your acceptance, or what are the essential things relating to your acceptance. So let's see that. So first essential or the first valid thing is very important. The first valid thing is the acceptance must came from to whom offer is made. Okay, the first thing is that when we are giving offer to whom person, to whichever person we are giving or offering our offer, the offer's acceptance is just only come from that person only, because we are just creating our offer on the behalf of that person only. No any other person, no any other person who is not representative of that offeree person is going to be accept that offer, because the offer is going specifically to that person. We all know that the offer is generally mean to the two types. The first is a specific type of offer, and in a second is a general public offer. In a case of general public offer, the public is also decided. Okay, whenever we are giving to offer to any specified type of the public, so it is generally accepted by that public only. So in short meaning, whenever you are giving acceptance or you are receiving an acceptance, you must see that who is giving that acceptance. The acceptance must come from that person who is getting that offer or who is getting that invitation from your side. The first thing is very important. Then the second thing is the acceptance must be absolute. Acceptance must be absolute or unconditional. Whenever you giving any acceptance to any offer, this acceptance must be an unconditional and unabsolute, because if you are getting some condition within that acceptance, that offer is going to be void, because you are not accepting whole of this offer by as agree him, because you are getting some changes, you want some changes within that offer, that's why you are agreeing that condition within that acceptance. So in that case, what happened, when you are accepting any proposal with condition, at that time the original offer is going to be lapsed or going to be cancelled, and at that time when you are accepting and you are giving a condition, so that offer is coming as a counter offer, that acceptance is considered as a counter offer. I am giving an example. Suppose I am a person and I am giving offer to B person that I will sell my car to you for rupees 2 lakh. For that sales you have to be pay rupees 1 lakh in a cash and 1 lakh in a bank check. They come from after receiving that offer and says that I am accepting your offer to getting or buying your car for rupees 2 lakh, but I will pay only 50,000 in a cash and remaining 1,50,000 by check. So this acceptance is cannot call to the acceptance of my original offer, because in that case he is not accepting my whole offer. He giving my counter offer that he will buy my car for rupees 2 lakh for rupees 50,000 in a cash and rupees 1,50,000 in a bank check. So whenever you are adding the condition within your acceptance, that acceptance is become as your counter offer. So this important thing, second important thing is also you have to be considered whenever the acceptance is generated. Then the third condition is that must be in a prescribed mode. Whenever you are showing your acceptance to any person to who is giving you an offer, at that time you have show your acceptance in a prescribed mode only, because if you are not showing your communication or you are not showing your acceptance in prescribed mode, so that exception cannot be going to be valid in that case, because you have to be communicate within that gesture or within that communication level only. Suppose you are making an offer or you are making an application to a company to wanting any job, or in a general public sense in a newspaper you are seeing an ad of any company of any government department to inviting an application for a student who want to become a manager. So at that time in the last there is a written that you have to fill, if you want this job you have to be fill the application from this website. So you should be given your application from that channel only or that prescribed mode only, because if you not giving your acceptance from that prescribed mode, your acceptance is not considered to be as a valid, because there is a declared or the prescribed the whichever the acceptance mode is going to be accepted. So at every type of contract there is a certain type of prescribed mode to accepting that your acceptance. It may be a formal contract, it may be an informal contract. So whenever you are offering your acceptance to any other person or to who is giving you an offer, at that time you must show your acceptance in prescribed mode. Then the fourth point is acceptance must be communicated. Acceptance must be communicated. Must be communicated. Okay, in this sense you should understand that whenever you are showing your acceptance to any person, that time you have to be communicate to who person who is giving an offer. I am listening your offer, I am agree with that, but I am not showing you my acceptance. I just consider it into my mind. I am not communicated with you. At that time, that offer cannot be said as accepted, because you are not communicated to your offerer person. So whenever you are agrees upon any offer, at that time you show your communication, you should communicate with the offerer person about your acceptance. The communication mode can be any of the form. It may be in a prescribed mode or any other the general mode. You can vocally accept that, you can written accept it by the written basis, or you can give any your action basis acceptance, but you should communicate that acceptance to your offerer person, because at that time if you not communicated to the offerer person, he cannot understand that you are accepted that promise, and he is unable to understand how to complete that contract, or he is not able to understand that his offer is become as a promise. So whenever you are making an acceptance, it must be communicated to your offerer person. Then the fifth point is implied action. Implied action is acceptance. In a certain type of cases, if you are not able to communicate with your offerer person about your acceptance, but you are agrees upon that condition to whatever the work is conditioned or the remark in your offer, you just simply do that. You just simply do that work. So if whenever you are doing that work, the offer is actually conditioned as your implied acceptance, because you are getting that work, you are doing that work which is the conditioned in your offer, and you are fulfilling that condition. It means you are ready to do that offer, and at that time your action is communicated. Your action is communicated as your acceptance to your offerer person. So implied action or getting to done of any work is also conditioned as your acceptance about that contract. Then next point we have to see the acceptance to the whole proposal. Acceptance to the whole proposal. Now the sixth point is acceptance to the whole proposal. I am just prescribing first second point. When you are accepting any offer, you cannot enter any condition into that. So it is mean that you cannot accept any part of your condition, any part of your offer, and another part is cannot be rejected. Whenever you are accepting the proposal, any offer, you should accept whole the condition and whole the offer. You cannot just select some part of the offer as a acceptance and another one is cancelled. If you are just doing that, so already I am saying you that this acceptance is become as a counter offer. You are not accepting your whole offer, you just making a counter offer to your offerer person. Then the seventh point is your within time. Whenever you are accepting any offer, your acceptance must be communicated within a time. It may not be lapsing of the some time of period, because we also know that every offer have its certain time period. I am not specified any just type, because every contract, every offer have its certain type of period. It may be a 1 hour, 2 days, 1 week, 1 month, or it may be in a year. It have a some time of period, but that time which is required to acceptance of that period, it must be acceptance is communicated or given this acceptance within that time. If you lapse that time to giving your acceptance, that offer is going to be lapse and your acceptance doesn't matter with that offer. You should giving your acceptance to that opposite person or your offerer person within that such type of period. If that time period is going to be lapsed, your offer is going to be void. Then the 8th point is your acceptance is not before your offer. Acceptance not before your offer. You cannot show your acceptance before anyone giving you a proper offer. Whenever any person, your offerer has making you offer, then only you can accept that offer. In case if suppose A and B has talking together, that A's offer to B, if you are coming to picture with me, I will pay for your ticket charges. At that time B is not ready for that contract, B is not ready to going to the picture, but at the same time C is appear behind to A and he just came across and say, I am ready to come with you in picture and you will pay my ticket pictures money or the price of the ticket. So this acceptance is cannot be valid because that offer A offers only to the B, not to the C. So in that case C's acceptance is not valid because offer is related to B. That means any type of offer whichever is prescribed to any person is cannot accepted by any other person, and the offer if suppose is not making to you, so you cannot show your acceptance to that offer because still you have not offered for that work or any type of proposal. So you should wait for whenever your offer is made to you, you should show your acceptance afterwards, that you cannot accept before the offer is made to you. Then the 9th point is question and answer about the proposal or offer is not an acceptance. Whenever the two persons are just exchanging their offer and acceptance, at that time if the persons is not getting the what is the point relating to the offer and they are just question and answering about that, so this conversation cannot be considered as your acceptance about the offer. Whenever the two persons are want to getting into the contract, at that time A is giving offer to B and B is not able to understand what are the condition or what are the function or what are the consideration about the contract, and he just asking question to the A, what is the consideration, whenever I am going to do that work, what is the benefit to me, why I should do that. So such type of this question and A is answering to that and B is going to be accepted or going to be considered for that question and answer, not to the whole project. He is satisfied with a question and answers only. In that case, that question and answer cannot be considered as your consideration or your acceptance about that consideration. You should wait for his actual acceptance, because he is just only asking a question about what is the conditions, what is the regulations about that your offer. So acceptance, invitations or offers, invitations, question and answer cannot be considered as your acceptance of the whole proposal. So you should wait for your actual acceptance of that proposal. And the last point is rejected offer cannot be accepted. rejected offer cannot be accepted. Whenever I am the offering person, but I am first time I am just cancel or not reject that your offer, but after some time I want to do that work, so I cannot just simply accept that offer. At that time any of the person has to make the fresh offer to me. That time I can only accept that proposal, or I am just accepting that, but that acceptance cannot consider as a acceptance to that original offer. At that time I am making the counter offer. Whenever you are rejecting any offer, it just become a void or cancelled, and after that period no acceptance is related to that original offer. If I am accepting that, so that offer, that acceptance is become as a counter offer to that whole proposal or to the whole new contract. So this is the basic 10 essential points which is related to any valid acceptance when you are wanting to make your contract with any person, and this is described in your Indian Contract Act section 2B. So you should complete or fulfill all of these basic essential 10 essential whenever you are giving acceptance to the any of the offer. Okay, so this is the acceptance point. Next point we will going to see that what is the capacity of the parties. What are the capacities of the parties? We all know that under section 10 of Indian Contract Act 1872, whenever the agreement is going to be accepted or going to be accepted by the capable parties, is become as your contract. Okay, so in that sense we understand that under section 10 the agreement is whenever the made when the your acceptance is come from the capable parties. So which are the capable parties in a contract, or who is capable to doing that contract, we are going to understand these things. So under section 11 of Indian Contract Act, your capacity of the parties is described, is your party's capacity is described. So capacity means what, or the who is the party. Your contract is going to be made whenever the acceptance is came from the person who attaining his age of majority, and the person who is in his sound mindness and able to make decision on himself, and the person who is not disqualified by any of the law under the contract or the any of the law within the country. That person only is capable to make that contract. So we can just summarize this definition as this thing: the person, the three person who is a getting his age of majority, second who is a sound mind person, and the third one who is not disqualified or who is qualified by law. If any of the three person can make any type of contract. So we will just discuss all these 3 points. So first party is your attending age of majority. The person who is attaining the age of majority. So what is majority? Under the Indian Majority Act 1875, the person who completes his age of 18 years old, that person is called as your major person. who attained his age of 18-year-old, that person is called as a major person. We also know that when we are completing the age of 18 years old, we are getting various rights from the government of India and under the various law. We can get the power of voting rights, we can get the driving license, we can get access of the bank accounts and the various types of the SIM cards we can issue on our name. So it just means that whenever we are getting or we are completing the age of 18, we become as a major person, and in that case also we are able to make any type of the contract under the Indian Contract Act 1872. There are some of the exceptions we are going to see in the next point in the disqualification of the parties. Then the second party is who is a sound mind person. Sound mind person. So is a sound mind person the person who attains his age of 18 years old. Who attains his age of 18 years old, and he is in his consciousness to able to make any of the decision for his favor of his interest. The person who is able to make decision for his interest or his benefit, he is called as a sound mind person. If we say that the unsound mind person is who? The person who is unable to make decision for himself, for his beneficiary, for his benefit. That person is called as a unsound mind person. If I want to giving you example, the examples are the mentally disabled person. Who is mentally disabled by any of the things. He not able to make decision for himself. He just dependent upon any other person. So at that time that person cannot make any type of the decision or any type of the contract for himself. Or another example is a drunken person. Any alcoholic person or any druggist person who is at that time, whenever he is taking that alcohol or whenever he is in that fever, he cannot make any of the decision, because at that time he is under the burden of that alcohol or any of the drug. So he is unable to understand what are the consequences about that contract, and he is unable to make that contract. So at that time he is a unsound mind person. So exempting all of this unsound mind person from sound mind, the remaining person are become as a sound mind person who is completing his age of 18, and that person can make contract under the Indian Contract Act 1872. Then the third point, the third party is your disqualification or the qualified person. Qualified by law person. The person who attains his age of majority 18 years old, who is a sound mind, and he is also qualified by law to making that contract, is called as a qualified by law person. So what is mean by qualified by law? The person who is not disqualified by any of the law of the contract for making any type of the legal activity within India. It just means that the person is not going to be disqualified by any of the law of the person. He is not restricted to doing any financial, any legal or any other type of the activity. So which are this person? If I want to giving you example, the simple example is any foreign enemy or any foreigner person. If I want to make any contract with any foreigner person, it's suppose it is our enemy country. I am not just taking the name of any country, but you just guess that India and the China is going to be into the war, and whenever the war is faces within a country, I cannot make any contract with a Chinese person. If suppose it is a sound mind, if suppose it is a major person, but it is the enemy of India, so I cannot make contract with him because it is abolished under the Enemy Contract Act. So at that time that person is become your unqualified person by law. Or any other person is insolvent person. Insolvent means who is unable to pay any type of his liability from his whole of the property. The person who is disqualified by the law under the Insolvent Act by the court, I cannot make any financial legal activity with that person because he is actually disqualified by the court to making such any type of the financial activity. So that person is unqualified to make a contract. So the person who is qualified by law is considered as a capable party to make a contract. So both these are the 3 points or the 3 parties who is able to make contract under the capability of the parties under the section 11 of the Indian Contract Act 1872. Okay, so we will rest our video here. In a next lecture we will see what are the disqualification of the parties. Thank you.